Hi, everyone. Thank you for joining us today for this informative and important legal writing panel. So a little bit about me. My name is Annie Bagdasarian. I graduated Loyola Law in 2021. I work at a LA firm called Green Burlett Wheeler, and I do plaintiff civil litigation. I'm also a part of the Armenian Bar Association's Young Lawyers Division, along with Giselle, who is the host on this Zoom. I'll be the moderator for today, and we are joined by two accomplished, wonderful attorneys who will be speaking on a range of important legal writing topics. We have Sipan Parsegyan, who's based out of Houston, Texas, and Varujan Arman joining in from Canada. So Sipan and Varujan, I'll give you the floor for quick intros, and we can start with Sipan.
All right. Thank you very much, Annie. And thank you to the Armenian Bar Association for the invitation. Hopefully those that have joined in will find this helpful. So as Annie said, I'm based in Houston, Texas. I've been practicing for over 12 years. I'm at a firm in Houston called Beck Redden. We're a trial litigation boutique, one of the premier ones in the state and nationally. And our focus is on trial litigation. We do pretty much everything except personal injury type cases, so commercial litigation, intellectual property cases, product liability, and legal malpractice, everything in between. Obviously, being based in Houston, a lot of what we do is related to the energy industry, but certainly by no means just that. And so, being in the courtroom and being an oral advocate is certainly part of what I do on a daily basis, but obviously legal writing is a huge component of that as well. Outside of my practice, I'm also on the board of the Houston Bar Association, and I have various other legal type community activities that I participate in.
Hi, everyone. I'm Varujan. Thanks so much, Annie, for the introduction and to the ABA for having me here. And thanks, everyone, for joining. I'm practicing in a firm called Blaney McMurtry in Toronto, Canada. I have a general commercial and civil litigation practice here. I'm a partner of the firm since 7 or 8 years ago, and my practice is pretty varied. I do a lot of shareholder disputes and fraud investigation. I'm also an accredited forensic investigator for fraud claims, and I also do a fair amount of construction litigation and some professional liability claims as well, so defending engineers, sometimes also actually suing lawyers, although I never like to have to do that. I also sit on the board of the Canadian Armenian Business Council here, and will also be involved with the Toronto chapter, newly founded official Toronto chapter of the ABA, which is great.
Awesome. So thank you both again for being here and sharing your knowledge with us today. So for those of you who have joined us, we're going to go through the life cycle of litigation from complaint all the way to trial documents. We'll then open it up for a Q&A session. You can either unmute and ask your question at that time. Although if the speakers are talking and something comes to your mind, I want you to please write it in the chat and send it to the host, and we'll read it aloud for you during the Q&A portion. This is a really good opportunity to ask questions. This is supposed to be very interactive, so please don't hesitate. Alrighty, so we're going to start with pleadings, and this is usually the first main document in any case. And what entails pleadings are usually complaints, answers, cross complaints. It's the birth of the case, and it's how you notify parties that the case exists. So general questions that I think I had when I first started off was how much, I still have now, how much to include in a complaint, things you can do to avoid like future documents like demurs, and just, general advice that the two of you might have for attorneys.
Varujan, go ahead.
Well, one thing did jump to mind from one of your questions, which is carefully studying the requirements and the legal test for each cause of action that you are going to plead, never taking it for granted that you think you've got, the test for, a certain business tort by memory. So I always like to double check on that and make sure that I've got all the facts necessary to fill up the legal test. And I'll be quite direct and literal about it when I plead that section of the pleading. I will basically organize the facts and say that each branch of that legal test is met. But more generally than that, I would say that if you're on for a plaintiff drafting a complaint, it's the origin of the lawsuit. So it's telling a story, but I like to, like all my writing, and I think this theme will come throughout my comments for the whole session, I like to focus on brevity and concise writing. I try to focus on the plain English movement and pretend that, the person receiving that claim maybe isn't a lawyer. At some point, it's going to be read by the party themselves, the defendants themselves. And I really want the defendant to understand the nature of the claim and the seriousness of the claim being brought against them also, not just their lawyer or a judge who's reading it down the road.
Okay, so yeah, all very, very good insights by Varujan, and which I certainly echo. I think I'll take a step back and first, when you have in front of you, we call them a petition in Texas just because we need to be different. And so, but same thing, complaint. And when you're faced with needing to write one, I think your intent and your purpose for writing it has to be one of the first questions you're asking yourself. And so there can be a lot of different reasons why you're writing this complaint and you're filing this lawsuit to begin with. It could be to compel the other side to want to mediate, or force them into settlement discussions. It could be have nothing to do with the party that you're suing, and it has to do with more public facing issues. It could be a PR type strategy. It really, or it could be something related. If you're teeing up a legal issue, it's more for the judge, and it might not even be for the trial judge. It might be for the appellate judges who may be reviewing this later down the line. So it really depends on what the purpose of this lawsuit is. If it's more of your, why we normally think of filing a complaint, which is you have this dispute and you want to see it through to the end to trial, having the complaint, that exercise gives you a really nice opportunity to put down a nice outline, not only of what your claims are, but where you want to go in discovery, and all the way through to when you're about to impanel a jury, and at the end of trial, when they have a jury charge that they're faced with, and you have your jury questions in front of them, going through the elements the way Varujan was mentioning earlier, that is all kind of born in the complaint. The seeds are planted there. So that all has to be put in mind. Of course, the pleading standard needs to be met, as Varujan was also mentioning. In Texas, it's a very lax pleading standard at the state level. Federal, obviously, is more robust. But yes, a narrative helps. But assume that, a judge isn't really going to be, especially at the state court level, a judge isn't really going to be reading your complaint or petition when you file it, until there's a motion to dismiss or some type of dispositive motion, or perhaps a very large motion to compel a discovery response. Then they may go back and say, well, let me see what the story is here from both sides and see what they've said. And so that's it. The one other point I would make is the way you craft your allegations in your complaint. Have in mind, if at least in Texas, in state court, you can just file a general denial. You don't have to deny specifically each and every allegation. But in federal court, of course, you do. And so teeing up, specific facts that you want clear denials on from the other side, or to force them to make those decisions to address it from the outset in an answer, possibly verified, can be incredibly helpful down the line in depositions and eventually in trial.
Okay, awesome. So we filed a complaint, but next up we have motions and writings from the other side that might come our way. One of these is a demurrer. So assuming we take all the facts in the complaint to be true, does the complaint state a cause of action, right? So in other words, is there a legal basis for the defendant to be held responsible? And that's the notion behind a demurrer, and it's a tool that can be very effective. And so when you're faced with a demurrer, I think some general questions might be, how do you oppose it? Or what are some strategies you can use in opposing demurrers? Or when do you decide to bring a demurrer? And also, whenever you are opposing the demurrer, what evidence can you look to? Can you look outside of the complaint? Are you confined to the complaint? So I'll pass it to you guys to talk about demurrers.
Yeah, so Fajan, you want me to take this one since you took?
Sure. Do the American version first. We've got the same rule, and this, I believe, the law of it is kind of the same. It'll be interesting to see if there's differences, though.
Okay. Yeah, and my kind of my response wasn't going to be very legal in nature. It was going to be more kind of tactical. But I'm happy to address any legal points, any of that you want me to. So I think one big mistake that I see a lot of, junior associates, and myself included, at the time make is when you're drafting a demur, or an answer. Well, I'm sorry. So when you're drafting an answer, so you draft it, you draft your general denial, and for the demur or the motion to dismiss, the language used is quite extreme or absolutist. Lots of adverbs being used. The arguments made are erroneous, incredibly incorrect. All this kind of language. And you need to realize that filing a demur or motion to dismiss, you're absolutely on your heels, and the law is designed to make it that way, to read everything as true in the four corners of the complaint. And so you really, if you're going to file one, make sure that you have a good strong basis for taking the court's time, to entertain this. And courts, it's absolutely, you're putting on the wrong first impression with the court, and they will notice when you just, as a matter of routine, are filing a demur, motion to dismiss, and when you look at it in substance, there's nothing really there, to rebut. And so that's why we sparingly will file motions to dismiss. It's truly only when we feel like the plaintiff has missed an element, or has made, as a matter of law, some type of technical error. So for example, in a recent case I had in Northern District of Texas, there was and it was related to wind technology. A property owner was not very happy that wind and solar was getting developed nearby and filed this lawsuit, and it was, just all over the map. And, certainly you could tell that there's no evidence behind it. However, of course, because at this early stage, you take it all as true. But the one portion was for amount in controversy, and she hadn't pled the proper amount in controversy to get over the $75,000 threshold, and had just made very vague, outlandish accusations as to what damages might be without any numbers. And that's what we attacked, and only that. None of the other stuff that clearly the judge can see has no substance behind it. And the judge, but however, you do include that type of stuff in your narrative, hint at it. So, the judge put the judge on notice that a lot of what this plaintiff is saying is crazy, has no foundation to it factually, but that's not why we're here. We're here on this legal issue. And that will inform the judge and give them a heads up. And so hopefully they agree with you, and you've given the judge the legal hook that the judge needs to rule in your favor.
Yeah, so interestingly, it sounds like we have quite the same thing here. We call them motions to strike, or a motion to attack the pleading if it is an abusive process or it lacks any reasonable cause of action. But we have this exact same rule that you assume that everything pleaded is true, and also there's no extrinsic evidence that can be brought into these motions. So I think CPAN nailed it. Like, I use these motions very, very judiciously. Part of the reason is, usually these are at the outset of the file, right after pleadings are exchanged in most cases. And from a strategy perspective, I would hate to start off a file with a loss at the outset and got the other side get a cost award against my client and put wind in their sails at the very beginning, right? So I want to try and control the frame, control the timing, and basically the whole frame of reference of the lawsuit to the extent that I can. So I use these fairly rarely, and the threshold for a pleading to pass muster here is not terribly high. So yeah, I really reserve them for the clearest of cases. And as a defendant or a respondent on a motion to strike for lack of particulars, or for lack of disclosing any reasonable cause of action, that's sort of, you look for any opening you can and say that we haven't heard the discovery evidence yet. We have to assume that these facts are true. even though this fact it may be unlikely that X was true, there's still a reasonable chance, our client should have a fair opportunity to try and prove it. And, if not, then the other side always has their motion for summary judgment after the fact. So, our courts are very hesitant to dismiss things on technicalities and wants to have things heard out on the merits. So that's basically the drum I would be thumping if I was responding to any motion like that.
And one thing to also note here, before we move on, that always when you're the one filing the motion as well as the party responding, always remember that the court, I don't know how it is in Canada, Baujan, but here, the court has the option of dismissing with prejudice or without. And chances are that they're going to give the plaintiff a second chance, a third chance to amend. And they're quite lenient in that regard. And they're, because they're, scared to be overturned on appeal as well on these kinds of things. And so they want to make sure it's locked tight if they are going to do it with prejudice. And so, that's why you shouldn't spend all of your capital with the judge, arguing and in extreme terms, like I was mentioning earlier, in your demur. So just point that out too.
Awesome. Yeah, I like that there's a theme here of building credibility with the judge and picking your battles wisely. And really choosing the word choice that you put in there and not being too dramatic, because judges are smart and they do catch on to that. So I like that you both brought that up. Okay, so going down the trail of the life cycle of litigation, it comes to the dreaded MSJ, motion for summary judgment. I don't think this really needs an introduction, but it's basically a way for a party to win a case without a trial. And it's definitely not something that you want to lose on if a motion for summary judgment is brought against a case that you're working on. So whenever, I have a motion in front of me for summary judgment, the first thing I ask is, where do I start? Because it's intimidating. It could be 100+ pages of exhibits and evidence that they throw at you. And there's so many different components within an MSJ. You have your separate statement, and you can have expert declarations, and your evidence too. So I will pass it along to you to kind of give us some of your strategies on how to tackle MSJs and MSAs as well.
So I've got to say, summary judgment motions are probably my favorite type of motion. Unlike CPAN's awesome experience doing so many trials, here the settlement rate is really, really, really high. And not just because Canadians are the most polite, but we just don't take things to trial. The court time is too hard to get. The delays are too huge. And so we spend more time with motions and mediations, and cases get resolved that way. So summary judgment, I think it's fun because you really get to you've built up the whole case, you've gathered the evidence. But I will say at the outset, I really think very carefully first about bringing them, and I never rush into them, even if a client is, hounding me to get going on a motion and they want to bring it. I will ruminate on it. I will think about the issues, even like off working hours. Like I could be, in the shower, I could be on a jog, and I'll be mulling over something that was nagging me. There could be one or two small issues that are preventing me from bringing a summary judgment motion, because here, at least, the legal test is the judge has to be able to fairly and fully adjudicate the motion on the motion, and that there be no genuine issue for trial. So you can lose a motion in two ways here. If you're the moving party, you can lose just because the other side actually proved their case and proved yours to be wrong and convinced the court, or they can merely say, Your Honor, we need a trial. We need a full fact-finding mechanism of a trial in order to fairly adjudicate this. There are genuine issues for trial here. So that threshold is, you have to use caution with that. So I will really think about these very carefully, and think if there's one or two issues, that are nagging on my mind, I think how's the best way to manage them? And then I will go ahead and address those in the client's affidavit in support of the motion. So this is a case where I think you've got to take the bad with the good, and you've got to get out in front of it and address it, and not leave it for the other side to raise in their response and try and treat it like it's, you know, some kind of dispositive smoking gun. So the affidavit, I really try to use the client's voice as much as possible. Everyone knows that lawyers are drafting the affidavits, but I still think it resonates more with the judge if you don't put too much, you know, legalese and too much topspin on it that a lawyer would put. Make it sound credible, like this is something that the client representative could actually say. And then you get consistency when they sit in cross-examinations and they don't seem surprised by anything that they've said in their affidavit, right? You want to have continuity. And for what it's worth too, sitting down and really grilling your client on the difficult points before you start drafting the affidavit can also be really, really worthwhile. So maybe I'll leave it there because I'm usually moving party for plaintiff side summary judgment. So I'll leave it there, and Sipan maybe can talk about whatever he wants to talk about, but perhaps also a response.
Yeah, I'll get to response as well. But I did want to point out a few things, if that's okay, Annie. You're the moderator, so you can shut me up if need be.
Lord.
Okay, great. So I think the biggest mistake that I see folks make in MSJs, and which is very apparent from the motion when you're reading it, is how late they start preparing for a motion for summary judgment. And you know, if you're the week of your, you know, MSJ being due, and that's when you start putting pen to paper, you start researching case law, you are toast. And you know, for me, as a general practice, I start thinking about my summary judgment arguments, and I start drafting outlines of them, and I start researching the case law, or I get a junior associate to kind of help me on that stuff, even before I file my complaint, or if I'm responding to the complaint, more likely. And you know, because the legal issues that you start testing, and the arguments and the case law that you find either in support or not of your case, are going to inform the types of questions that you're asking in discovery, the deposition questions that you're asking, the types of testimony you want to elicit to help support your summary judgment record that you want to build. And so you know, that's all part and parcel of what makes an MSJ an effective one. You know, so that by the time you actually are in the actual drafting stage of your MSJ, you know exactly the discrete legal issues that you're putting in before the judge. You know where you stand on them. You already have your record built supporting it from discovery, and it's not something that you say, oh, I wish I had asked this question during this key witness's deposition, or I wish I had taken that person's deposition, or I wish I had asked this interrogatory when it's too late to do that. So, you know, so that's all, that's, I think, one of the biggest pieces of advice that I could possibly give is it's never too early to start thinking about your summary judgment motion. And, you know, so that's one. With that said, summary judgment motions are, at least, you know, from what I've seen, are starting to, you know, very quickly go out of favor with courts. And because they get flooded with these, you know, huge volume MSJs with all the evidence that goes along with it. And judges just don't have the time for it, and they sit on it. A lot of times they don't rule on it until the eve of trial, and parties are shocked that happens. They've spent so much of their, you know, the clients are shocked that they've paid so much money for these MSJs to get put together, and the hearings for them, and then just for silence for months, when they think that this is their golden ticket and it's their off ramp, you know, for the case to be resolved, and it just never happens. And so, you know, I have a case in Colorado right now where it's a state court case, and the judge has a rule that all MSJs and responses thereto have a maximum of 10 pages total for
Wow.
all arguments for your MSJ. And so at, you know, at first blush, that's incredibly challenging, and talk about an exercise in concision. That's your exercise in concision right there. But it's an illuminating kind of rule, because it really shows you what a judge cares about for MSJs. And you know, so you start it with an introduction that, you know, very brief, bullet point it, even if you have to. Here are the arguments I'm making, and here's why, you know, your strongest case law on each point that says it supports it. If it's a novel, you know, if it's an issue that's a first impression, tell the judge, you know, that, and then you have to convince them why to side with you, because, you know, they're going to be scared about being overturned on appeal on something of first impression. So always think about it from the judge's perspective and what their frame of mind is going to be reading into this. So I'll say that. On the response side, since Varujan put that on my plate, I again, there, if there's any type of factual implication there, you want to juice that for all it's worth and try to make it a fact issue as much as possible. And if there's any inkling of there being a fact issue, a judge, especially a state court judge, is probably going to side with you and deny the summary judgment motion or not rule on it. And that's exactly what you want. You want to cast as much doubt as possible within the realm of being credible and do that. On issues that are legal in nature, you have much less leeway there, and it's really a matter of just arguing the best legal side you've got, and hopefully you've done your homework ahead of time on your arguments, on your claims, so that you're not susceptible to being dismissed because of a case out there that you didn't know about and didn't research. So again, that's another example of preparing ahead of time and making sure you have your elements right and you know your case law.
Awesome. And then I wanted to ask a follow-up question about stylistically, how do you write a MSJ motion or how do you oppose it? Because I've seen a lot of MSJ motions come in where they're just blobs without unique headings. They will have headings like introduction, argument, conclusion. But how important is it to use concise argument type headings in your motions?
I personally love the use of subheadings, and I use them quite a bit in a summary judgment motion. It's the affidavits in support of those are usually a bit on the longer side as motions go, unless it's a really simple, statute of limitation issue or something that you're moving for dismissal on. So even within the facts section, I like to use a lot of subheadings to let the reader know, you're done with that topic now, we're moving on to the next. It just helps with the flow. And I'll use that even in the covering notice of motion. I don't think you guys have a separate notice of motion document in front of your affidavit, if I'm not mistaken, but I will use that. That's a document that just signals what the motion is, what we're asking for, and a brief summary of the story. But then the actual evidence is the affidavit that goes behind the notice of motion, goes along with it. So I'll use subheadings in both documents for sure.
Okay. And so, yeah, the only thing I agree a lot with what Varujan's saying. The only thing I'll add there is a good test to see whether you've effectively organized and displayed your arguments. Again, having in mind that the judge does not have a lot of time for these things, is to see, have someone who has no familiarity with the case read your table of contents, if you're allowed to have one for your MSJ, and see if they can understand what the arguments are from just reading the table of contents. At a high level, and if they can, then you've done a pretty good job of organizing your MSJ. And because it's you can even have a full sentence as a heading or a subheading, and to say very very succinctly, here's the reason why that this claim or this sub element it cannot be cannot be proven or whatever. So that's one good test to use.
Awesome, thank you. So the next thing, my personal favorite, motions to compel. And I see this in written discovery and also things like compelling a deposition. And I think important things in motions to compel are the meet and confer process, which are usually attached as exhibits to motions. And also